Morning, Your Honor.
Good morning.
And thank you for yesterday. I would have sent an email, but I don't remember August 8th email. Can you either let me see it or just tell me?
I mean, it says it appears the state's exhibits 430Y and 437Y are the exact same video. Shows Mr. Sledge, Mr. Jeffery Williams, Mr. Shannon Stillwell, and others in-house talking over each other. Mr. Sledge flashes money. And I don't know who you're talking to then, but it says, can you explain why either proposed exhibit is admissible and why are there two proposed exhibits?
I think we dealt with that, not yesterday, but earlier this
I
week.
thought so too. I just wanted to double check before I cross that off my list also. Okay. All right. So do we want to do the other, were there any issues with the other CAD reports that are in the second Sharon Latner folder?
Your Honor, I have not received any objections from defense counsel related to
Okay.
the exhibits in that folder.
Are there any? It would have been in the group of 31 through 60 witnesses and the counts 3 through 7 folder, the Sharon Latner folder within that.
Judge, I didn't see any issues with the CAD report that haven't been previously discussed. However, I'm still obviously going through them again, but I didn't see anything preliminary.
Okay, well, told y'all to do that last night and bring them to my attention today.
Didn't see anything.
Okay. All right, I'm going to assume then that there aren't any objections to any parts of those CAD reports.
Understood.
All right. And were we going to come back? I can't remember. We were to the Jean-Pierre social media. Is that because y'all needed a chance to look at that?
Good morning, Your Honor.
Morning.
I believe that I was going to narrow down which videos we were going to use, and I did narrow them down. But what I did not do, and I will do that now, is email over the timestamps that we think are relevant that we would plan to introduce, so that defense counsel can take a look at it and maybe we can talk offline if there are any objections.
Okay. Did you get that finished last night or this morning?
I finished viewing it last night. What I did not do was email the timestamps.
Why did you not? So that they could have a chance to look at it before court.
That was on me, Your Honor. We were working on some other items, and so I just identified them, and so I will send those.
Try to, like, when I give you tasks that you're supposed to do overnight, so that we can discuss them the next morning in court or the next day in court, please communicate across the aisle to the other side so that they can also be prepared.
Yes, Your Honor.
Thank you. It's not unreasonable. And then we were going to come back on counts 27 through 29 to something with Smith. I can't really decipher my notes sometimes. What was that about?
Perhaps, Your Honor, this is something that I brought up about the videos. I knew that there were several videos of co-indictees that are not sitting for trial doing live streams and kind of broadcasting things to the world about this alleged crime that none of us are charged with.
Okay.
And I raised some concerns. One of them, I understood that the state had a video of Mr. Beebe wearing a trap commander chain, but I was suggesting that maybe a still shot would.
Yeah, y'all, the state would, thank you. The state was going to narrow those down and figure out which you wanted to look at or which you wanted to use and which you weren't.
That's what I just addressed, Your Honor. Those are the timestamps. Those are the 3 videos that we looked at. We have identified the relevant timestamps of those videos.
So that's all the same thing, the Jean-Pierre social media and that's
Video
within
camera.
count, okay.
And there's video camera that puts my client and a car that he's in, and allegedly Demikian Garlington's in that car, although he's never seen on any sort of video. That's the state's allegation. And a separate car is what appears to be Mr. Nichols and Mr. Farley in a car, and I think they're alleging Mr. Boyer is also in that car. They're on video at the gas station. By happenstance, Mr. Drinks pulls up to that gas station after they're already there. Now, let me be very clear. Mr. Stillwell did not commit this crime. However, I will say that Mr. Drinks was shot within minutes of him showing up at the gas station where these gentlemen already were. So by even the state's theory, there's no conspiracy to kill Mr. Drinks. It's sheer happenstance. And by the state's theory, which we are saying is not true, the decision to kill Mr. Drinks would have occurred within minutes of the death.
Okay.
So there's not, so it's all based on happenstance, a chance encounter according to the state's theory. There's no grand conspiracy here.
The two aren't mutually exclusive in that there could be a conspiracy to kill people whenever you happen upon them. So, I mean,
Okay, and
you can make that argument, but they can certainly make the counter argument.
Okay, and in that case, if that is a conspiracy to kill people, and again, we're just kind of assuming that there's no evidence of that, but nothing in this call furthers any such conspiracy.
Well, honestly, it would have helped to have known what you said after the call, before the call, so that I know what I'm listening for. So I'm going to need to listen to the call again. Okay. And then let's do it the other way for the remaining calls.
Will do.
Thank
And
you.
also, there was, since we're rehearing it, I'll tell you that you're going to hear in the call, one apprising the other that SB is laying low with his folks. There's that comment in there, but I'll play it again.
All right.
Oh, that shit was Chris name.
Yeah, man.
Yeah, that shit, that was crazy, boy.
Man, I'm just going through what I'm calling when I had them posts. He told me, tell Corey, I said, what's wrong? I told you that.
Yeah, that's why I got that on, like, man. That shit, that just too crazy.
But that's a fool. Boy, I'm like, damn, boy.
They hit on more though, this.
I don't know. See, I think he the one that just got shot in the head. I don't. Like, everybody been said he hadn't died first. Like, that's what they were saying at first.
And Judge, just so that the court has further context, Shamel Drinks is DFW, and DFW, I said that wrong. Hold on. I'm sorry. I was reading notes. We think a timeline might help you as well, so we're going to give you a little bit more background than what I just gave you. We're going to start further back.
So, Your Honor, just so the court is aware, we believe that the Shamel Drinks murder is the culmination of a few different events, really starting in February of 2022. On February 9th, 2022, Rayshawn Bennett, also known as YFN Lucci, was stabbed in the Fulton County Jail by Jaden Myrick, a YSL associate. He did not pass away. So believing that they wanted to finish the job, on February 22nd, 2022, another YSL associate, Christian Eppinger, reached out to another YSL associate, Antonio Sumlin, to get permission to finish off what Jaden Myrick did not do. That information about Mr. Bennett being stabbed in the jail in February hit the media sometime early March. I think maybe around March 3rd or March 4th is when that information was released to the media. On March 11th, in the early morning hours, that is when Christian McMiller and Darius Ford were murdered. Pending that release, we believe that they were murdered by Wyeth and Associates. We have shell casings from the murder scene that match a shooting that happened on March 16th that I'll get to in a moment. After the shooting of Mr. Ford and Mr. McMiller in the early morning hours on March 11th, there was another shooting on March 12th in which a YSL associate, Stephen Harris, shot at in the direction of 12 Atlanta Avenue, which is a YFN stronghold, hitting a YFN associate. His name is escaping me at the moment. Following that, there is a call that the court will hear in a moment in which there's a shootout on Cleveland Avenue in which Demekion Garlington and I believe Mr. Stillwell are involved in the shootout on Cleveland Avenue. Following that, in the morning hours of, I believe it's the 13th of March, it might be in the early morning hours of the 12th of March, there is a drive-by shooting near 2830 Waters Road. This is what we believe is the trap house of Big Nick, who is, I think it's Nicholas Carter, forgive me on the last name, but he is a YSL associate. Following that shootout is when there's some social media postings, Your Honor, in which Shell Kel, who you've heard of, Kelvin Watts, repost a picture with Shamel Drinks, Kelvin Watts, and another individual that could have had some subliminal messaging that they were the persons responsible for killing Christian McMiller and Darius Ford too.
Okay, thank you.
So, Your Honor, our position is that what he is pushing back against, and it's the context of that statement that is the most important, because they're trying to tell, they're trying to relay to keep someone calm, and that they were talking to Onfont, who was a co-defendant who pled guilty in this case, and they are alarmed at the fact that another member is potentially on a jail call saying that we did that for bruh. And that's the point at which Shannon is pushing back, saying like, what? Right. Like, I can't believe that. And then he's like, nah, you know, he didn't do that. And the other guy says, you know, I don't know, he could have been on a cell phone or what, but that's what I heard him say. So his alarm isn't at, he's lying on me. His alarm is that, and this is what we would argue, of course, anyone can make their own arguments at trial, but we believe that this is what the evidence shows, that the alarm is at the fact that this person on a jail phone is saying something highly incriminating to them and sharing this information between them all. And the alarm in itself is evidence of the fact that this whole conversation is in furtherance of that conspiracy, which is the enterprise that is YSL and the criminal street gang activity of YSL. So none of it is hearsay when all of it is statements of a co-conspirator. It is their reaction to their belief.
It's still hearsay, even if it's a statement of a co-conspirator. So, I mean, at some point y'all are saying, this isn't hearsay because we're not offering it for the truth. So I know that's not what you meant, but let's try to keep the terminology clear.
You're right. You're very, very right.
And I didn't mean to interrupt you. I just want to make clear, like, you know, we have got to all be clear about what we are saying and what we mean by what we're saying.
Your Honor is absolutely right.
All right.
And so that is, we are saying that there is an exception.
Right.
And that this is the exception that it falls under.
Okay. All right, and so again, I understand that the conversation between Stillwell and Garlington might come in under a co-conspirator exception to hearsay. The thing that is at issue is the relaying of Nichols allegedly having said, you know, whatever he said, you need to line up a lawyer or whatever, you need to pay for it because we did this for Buddy.
Right.
And the concern is that either that part is being offered for its truth, or even if it's not, that certainly once the jury hears that, they take that as evidence that it is true.
Understood. So I
So
hear more clearly.
do I understand you to be arguing that that part of that is also co-conspirator exception, or no?
There, I need to address that part of it. So one moment, Your Honor.
Sure. Do I have the argument correct that y'all are propounding?
Well, yes. And if, while they're gathering this, Mr. Atkins is listening, I hope. So can I respond? If we break this down, here's what the sentences were. Garlington says, I talked to Funk. I've been with bruh. I don't know who that is. And he, I don't know whether that refers to Funk or bruh. And he had me on FaceTime. That could refer to either one of those people. What's up with Quay? That's the next question, next statement. Why the hell? I don't know. Quay on the phone saying something like, I don't know if he, and again, we got a he on shit. I don't know who the he is referring to. He told Rel, that's another person, that's another layer.
Well, that's somebody who's listening. That's not somebody who's talking. So anyway, and also, can I get this portion of what you've written down as a transcript? Because it would be most helpful.
I can give you what we have, yes.
Okay, great.
But I'm breaking it down because now we're on a third person. He told, I don't know.
Okay, but that's a listener, so keep going.
Okay, he told Rel, and I don't know who Rel is, and I don't know whether Rel told Funk, and I don't know whether Rel told Bra.
Right.
We have no clue.
Okay, but keep going.
Okay, he told Rel, like, tell Buddy, god dang, get a lawyer, bruh. We did that shit for him, he paid, you know? And then Garlington says, you know what I'm saying, to Garfield. To Shannon, I'm sorry. And Shannon says, what? And Garlington says, yeah, that's what Funk told me. He was like, tell homie to chill out, bro. Now who's homie? And who's the bra? I mean, we have so many layers of unknown, and nested hearsay is exactly that. That's the whole point.
Okay, so the short answer is yes, I've got your argument
Okay.
correct in terms of understanding what it is you're arguing.
Yes.
Okay.
Your Honor, to be clear, because I may not articulate this well, my position with what Mr. Harvey just broke down, at least what these statements they say.
Yeah.
Un Funk, who was a defendant in this case, and the state believes was a YSL street gang member, him telling Garlington that Nichols needs to chill. Un Funk isn't charged with the murder of Shamel Drink, so him telling him that is a statement in furtherance of the conspiracy.
Nichols needs to chill. That's not what I'm concerned about.
Yes, Your Honor.
Okay.
But
I'm concerned about the Funk saying Garlington saying Funk told him that Nichols said he needs to pay. We did this for him, so he needs to get us a lawyer.
And Your Honor, the state feels.
But said it to Will, not to
It doesn't matter who he said it to. But it sounds like Funk heard it regardless.
No,
Do I have that part wrong?
I think you do, because
Okay.
he said it to Rel. Rel said it to somebody else.
Nichols said it to Rel.
Well,
Allegedly. Allegedly, I understand.
Yes, yes. And then Rel to Funk, then Funk to Garlington. So that's 4 layers at least.
So, Your Honor, two things is, and the court may just disagree with my argument, which in terms of.
What I'd like is some law.
Yes, Your Honor. So the case law I was referencing earlier, I will find this date, but there's no double hearsay issue. The statements are admissible without a showing of the declarant's personal knowledge. And I may have been off kilter where I was thinking of, this is what I was thinking of when I referenced to the court, that there's not double hearsay in this statement, is that and I will just cite to this motion because the court can read this, but I will find the date. But the state's position is that it is co-conspirator. It is in furtherance. Like the fact that Garlington is concerned or receives this information, that Nichols made that statement.
I understand that part. I agree with that part.
So the colonel, that part in the middle.
You understand what my concern is,
I do.
Ms. Love. You seem to understand it before, and I'm sure Mr. Atkins understands it too. He's just too busy looking up trying to find the law. Go ahead.
That colonel in the middle, that Funk said, Nichols tells somebody, we did this for bro. Nichols saying, we did this for bro. Nichols saying, we did this for bro. I'll start out by saying, at best or worst, whichever you might want to look at it, Nichols is implicating himself and not Shannon necessarily. He hadn't said Shannon did anything. He's saying, me and somebody else did this for bro. So that's to start there as to Mr. Sharp's argument that it necessarily implicates Shannon, who has to push back. Number 2, Funk being a co-defendant of Mr. Nichols and a co-conspirator of Mr. Nichols, relaying what Mr. Nichols told to him, whether or not Mr. Nichols said it or not, it's statements that Funk is asserting Mr. Nichols gave to him, even though it's a statement against the penal interest of Mr. Nichols. The reliability of the statement, the statement itself being the hearsay issue, we believe is dealt with in that it would be Mr. Nichols, a co-conspirator of Funk, relaying something in confidence to Funk, or saying something in confidence to somebody else who he considers a person reliable enough to share something that inculpatory with. Funk is not trying to harm Mr. Nichols, so he's not going out lying on Mr. Nichols. He's sharing this information in an effort to help Mr. Nichols, get him to shut up and stop talking. They all are trying to get him to stop talking. So in terms of the reliability of the information, nobody here has any reason to share inaccurate information. It only furthers their purposes to be truthful about what's happening so that they can further protect themselves and inoculate themselves from any harm coming from this man talking. So the harms and dangers of hearsay that are normally present when, the whole reason it's kept out is, we don't know if it's true or not, are handled and dealt with by the circumstantial, I hate to use this, guarantees of trustworthiness given that are present in the way that this statement comes about. It's told in a way, it's relayed in a way that indicates it's shared in order to help, not to harm Mr. Nichols, to help all of them and keep them safe. So it's layered co-conspirator hearsay, if you will, but that first relaying of information, the declarant, Mr. Nichols, saying it to Onfunk, it would be definitely a statement against penal interest. But Mr. Greer, who is Onfunk, sharing that information is a co-conspirator statement, which we believe gets us past this idea that this is nested hearsay. And as far as the 403 argument that is being made, in order for it to be so unduly prejudicial as to permit its exclusion, it would have to lure the fact finder into declaring guilt on a ground different from proof specific to the offense charged. And that just doesn't exist here. So we don't believe that they have met, and by they I mean the opponents of this information coming in, they have not met their burden of showing that this statement from Onfunk regarding Nichols telling on himself, and basically Nichols trying to get help for himself, like bro needs to pay for a lawyer. We did it for him. We don't believe.
Hey, no, sir, Mr. Harvey, stop right now. Stop right now. Stop right now. Mr. Harvey, sit down. I am not going to have you interrupt court. You may object in just a moment. We will get your objection in a moment. Go ahead.
Thank you, Your Honor. There has been no showing that this information is so substantially more prejudicial than probative that it should permit the exclusion of what we believe is obviously relevant evidence.
Okay, thank you. Mr. Harvey, your objection.
My objection is for lying to the court. Making things up to the court. You saying speculating to the court that I assume might you paid for Mr. Nichols. You got the evidence of that?
I don't even understand that to be what she said. Okay, well, the record will reflect what she said, but I understood her to be talking about what was being said within the context of this conversation we just listened to.
Your Honor, just
Yes.
sorry. Go ahead, Mr.
I missed any reference to so well. Well is the person to whom this alleged.
I'm going to listen to it again. Offline, not in court.
Your Honor, this is where I'm at with this. Just because the state says something is so doesn't make it so.
I understand.
And the state is saying, oh, well, this was done in furtherance of the conspiracy. This was done in furtherance of the conspiracy. The whole point of the hearsay rules, and I understand that the confrontation clause might not be implicated here, but the hearsay rules, the whole point of the hearsay rules is you get to see who's saying it, know what their basis is, you get to cross-examine them, they come to court, etc. And the problem here is the state is just sitting here saying, oh, well, clearly Mr. Umfunk did this to further the conspiracy. And how do we know? How does she know? Maybe Umfunk, I'm not saying this is the case, but what if Umfunk was involved? Umfunk would have every reason to shift responsibility to other people. What about the next line in the hearsay ladder that we have? We don't know what people's motivations are, and just because the state says, well, their motivation was to do this or do that, she's not inside Unfunk's head. She's not inside Rel's head. So I reject that their argument that they can just label things as hearsay exceptions and it makes it so.
Well, I understand that. I take what everybody says as your argument in support of your position. I don't accept it as fact. It's an argument. I hear the counter argument. Sometimes I hear a lot more counter arguments back and forth after that, and then I make a determination about whether our evidence rules permit this particular evidence. The point of the hearsay rules and all of the evidence rules is so that, to the extent the court can help it, only trustworthy information gets before the jury. And that's what we're trying to sort out here. So I understand that the stakes are high. I think that this might be a good time to break for the day.